I'm Colin Singer, immigration lawyer and managing partner of Immigration.ca. Canada Immigration News Articles, June 2015. The Dilemma of Canada's 4-in, 4-out rule. Tens of thousands of hard-working and law-abiding temporary foreign workers living in Canada were set to be deported starting this past April following the implementation of the cumulative duration rule, also known as the 4-in, 4-out rule. The rule is arguably representative of the unfairness of Canada's revolving-door system of worker exploitation, with temporary foreign workers deemed to be disposable workers. The 4-in, 4-out rule stipulates that foreigners working on temporary worker visas for 4 years who have not acquired permanent resident status must leave the country for 4 years before being allowed to return. The law has been on the table for quite some time, but it seems to have been ignored by the majority of those affected. Yet the vulnerability to deportation is making thousands of temporary foreign workers deal with the difficult task of sorting out all their affairs and packing up their lives in a very short space of time. Families are being placed under a lot of stress. While foreign-born children are required to leave Canada along with their temporary foreign worker parents, Canadian-born children of temporary foreign workers have Canadian citizenship and are allowed to stay, thereby putting the families in a difficult situation of having to live apart. As the numbers of temporary labor migrants have grown over the last decade, the cumulative duration rule is the approach the federal government has adopted to limit immigration to Canada through temporary labor migration programs. The introduction of the rule comes following a period of lobbying from various groups who argue that temporary foreign worker programs take away job opportunities from Canadians who are struggling to find work in a challenging economic environment. The Alberta Federation of Labour, for example, believes that the temporary foreign worker programs provide a cover for providing employers with a mechanism that keep wages low when economic conditions suggest that they should rise. There are essentially two kinds of migrant workers arriving in Canada: long-term immigrants and temporary short-term residents. This distinction leads workers along separate paths and into different labor market segments, and eventually into a future as permanent residents and citizens, as well as non-citizens. For temporary residents who cannot transition to permanent residence, their path now requires them to leave Canada and return to their country of origin. In addition to working holiday programs, temporary workers are admitted to Canada through the Seasonal Agricultural Workers Program, the Live-in Caregivers Program, and the Temporary Foreign Workers Program. Low-skilled workers arriving through the Seasonal Program usually leave Canada within 8 months, and as such, are not really affected by the 4-in, 4-out rule. The Live-in Caregivers Program, which has since been abolished and replaced with a Caregiver Program, allows for the employment of foreign workers as domestic caregivers in exchange for a pathway to citizenship. The Caregiver Program allows for the employment of foreign workers as domestic caregivers in exchange for a path to Canadian residence, though changes introduced in late 2014 have made it much more difficult to do so. The Temporary Foreign Worker Program accounts for the largest number of temporary workers and has become the center of attention under new government policy. Meant as a stopgap short-term solution to fill severe labor shortages so businesses could grow and create opportunity for Canadians, the Temporary Foreign Worker Program has become the cause of widespread resentment among those who believe it causes economic hardship. This was brought to the forefront of public opinion when a major bank issued a public apology for hiring temporary foreign workers to permanently replace local employees, even though the temporary foreign workers were higher skilled. The number of temporary foreign workers has rocketed over the last decade, from about 100,000 in 2002 to about 340,000 in 2014. While a majority of temporary foreign workers in 2000 were high-skilled, by 2008, lower-skilled temporary foreign workers became the largest category. It is against this backdrop that the 4-in, 4-out rule was enacted. However, clarifications are in order. First, the high cost of recruitment, travel, and other fees, including $1,000 in government fees associated with employing temporary foreign workers, can lead to exploitative instances of debt bondage for temporary foreign workers who are made to work off these employment costs or loans by their employers. Second, many temporary foreign workers choose to work overseas, including Canada, to secure employment at much higher wages than is otherwise available in their own country. Indeed, foreign remittances account for a significant portion of family income for millions of workers working abroad, from India and the Philippines, the world's top source of low-skilled migrant workers. Third, the 4-in-4 rule applies mainly to low-skilled temporary foreign workers working in manufacturing, retail, and hospitality. The Canadian government has formally exempted a number of high-skilled temporary foreign workers employed in management and professional capacities, as well as their spouses and dependents. The 4-in-4 rule gives rise to claims of an unjust and unequal treatment of temporary foreign workers based on class, skill, and qualifications. While higher-skilled migrants are often able to transition to permanent residence, the majority of temporary foreign workers in Canada who are low-skilled cannot. The 4-in-4 rule serves to reinforce an exploitative revolving door system that admits and then removes temporary workers who are seen as disposable. It is a difficult stigma that Canadian policymakers should acknowledge. At the very least, Canada must ensure the foreign workers coming here fully understand their temporary status. This will ensure that those choosing Canada do so under mutually beneficial economic conditions. Source: opendemocracy.net.